Hi, everybody. Happy Monday. I don't know if any of you watched the Formula One race in Miami this past weekend, but it was a pretty exciting race. Max Verstappen came from ninth position in the pole to the front and won the race. Very exciting. So, Formula One is a lot of fun to watch. And speaking of formulas, I thought today we'd talk about what is the formula for a living trust. What is a living trust? And what are the elements of a trust? What do you have to have a valid trust? What's the formula? Well, it's pretty simple, actually. You have to have, number one, a trustee. That's the person that's going to manage the trust. Number two, you have to have a trustor. That's the person that's going to execute or create the trust. Number three, you have to have beneficiaries. That's the person or the persons that are going to enjoy the money, have the right to spend and benefit from the money. In addition to the trustor, trustee, and beneficiary, you also have to have corpus. That's a Latin word for assets. You have to have some sort of property, real property or personal property that's in the trust. If a trust doesn't have any assets, then it doesn't exist. It's like a forest with no trees. A forest isn't a forest unless you've got trees. And a trust isn't a trust unless it has assets. In addition to that element, you also have to have a legal purpose. So a trust cannot be formed for an illegal purpose, to commit a crime or something nefarious. It has to have a legal purpose. Paying for a grandchild's education, allowing children to buy a home, passing a legacy or an inheritance on to children or grandchildren or a spouse. Those are all legal purposes, of course. So those are the elements of a trust. And if you have those elements in place, you've got the right formula. So let's review those, see if you remember everything. The trustor, that's the maker of the trust. And there are different words for the trustor. It could be called the settlor, the creator, the grantor. When you're reviewing a trust document, you'll see these different types of words. But basically, it's the maker of the trust. You have to have a trustee. That's essentially the manager, the person that can buy or sell the property in the trust. And the trustee actually has legal title. The trustee is actually the owner of everything in the trust. The beneficiaries are the owners of the beneficial title, and they're the ones that have the right to benefit from everything in the trust. A legal purpose, assets, and if you have all those elements, you have a legal and binding trust. It could be revocable, it could be irrevocable, but the formula is not that tricky. If you just remember those main elements, then you can create a trust. Typically, it's going to be in writing. There are some doctrines that say you can have a verbal trust, but most trusts and the more enforceable ones are in writing. So I hope that helps. Keep that in mind. And until next time, it's Dan Hales. Thank you for listening. Bye.